And councils, could you please state your appearances for the record?
Good morning. My name is Attorney Maisha Howard, P83967, here on behalf of Joni Campbell.
Eric Loretta on behalf of Evan Hummel, P37550.
All right, and ma'am, your name for the record? Ms. Campbell, your name for the record?
Joni Campbell.
All right, and sir, your name for the record?
Evan Hummel.
All right, and guys, I want to thank everybody for appearing via Zoom today. I realize even though you're appearing remotely, this is a legal proceeding just as if everybody was here and present in the courtroom. Ms. Campbell or Mr. Hummel, any questions for myself or your attorneys regarding that this in fact is a legal proceeding today?
No.
No.
All right, so we're here today on third-party petitioner, maternal grandmother's motion for grandparenting time. Counsel, if you would like to proceed.
Yes, Your Honor. So Ms. Campbell is the maternal grandmother of the children. While the children were growing up, they have lived with her during certain times. Their mother has indeed passed away, unfortunately, and Ms. Campbell really just wants to be able to get some grandparenting time with the grandchildren. She went from seeing them every day, living with them, being an integral part in their lives, to not being able to see them at all. And so she really hopes that she could get one weekend a month. And then during the summer month, she would like overnight weekends, one overnight weekend per month in June, July, and August, so that she could take her grandchildren to the cabin. Miss Campbell is very attached to these grandchildren. These grandchildren have spent a lot of time with her. They know her, they love her. And so we think it's in the best interest of the children to have some time to spend with their maternal grandmother and also keep ties with their maternal family.
All right, counsel, your response.
Well, first of all, there's very specific rules under 722.27, and it is the burden of the petitioner to prove by a preponderance of the evidence that the parent's decision, which is given great deference, will cause substantial harm, mental, physical, or emotional. I don't think an affidavit does that. Here's the situation. The kids are 5 and 4. At the time they're speaking of where she said she had contact with them, the parties were separated and had 50-50 parenting time. After, and the decedent, and I feel horrible, anyone who loses a child, you have my condolences, Miss Campbell, so don't think I'm being rotten. But her daughter, who lived with her, overdosed at least 3 times at her house. There's been domestic violence. Let me tell you, I didn't interrupt anybody. The daughter died of an overdose on the minor child's birthday, at the birthday party, at the petitioner's house. There's been domestic violence calls to that house. And since in post her dying, my client gave her some deference to take the minor children, but she started bad-mouthing my client on social media and doing things like that, and their relationship deteriorated. They live a substantial distance away, and we did make an offer pursuant to MRE 408 to give her some parenting time, but no overnights. She also has 2 big dogs. One's a 140-pound Rottweiler. The other one is another large dog. And my client doesn't feel comfortable in her having overnights. I don't think she's met her burden. And, we were trying to work something out. It didn't seem to go well because she's adamant about having overnights. And my client believes that will harm his children more than do any good. So that's where we're at. I think the statute speaks for itself, and I don't think they've come anywhere near proving their burden. There's been no professional, opinions given that this would hurt them, and my client's in fear for their safety because of the history.
All right, so let me ask a couple of questions here. So, Mr. Hummel, do you somehow attribute Miss Campbell, your children's mother's death and drug use to Miss Campbell, her mom? Do you think she's an addict? I mean, because obviously a parent's in a rock and a hard place. You have a child who's having drug problems. You can kick them out on the street, or you can maintain them in your home and try to help them out. Are you somehow attributing her drug abuse to her mom, or tell me about that?
So in all of this, the children were at her mom's house with her as well. So I feel like it was almost the addiction was just kind of allowed there.
And what was the addiction to, if I may ask?
Heroin.
Okay. So you think that Miss Campbell was permissive in allowing it in the house and her daughter to use it while she had 50-50 custody of the kids?
While my children were there, yes.
And
There, Judge, I just want to tell you, there was it was an informal agreement. Subsequently,
Okay.
on the third overdose, Mr. Hummel filed for divorce, and Judge Slutowski granted him full custody, legal and physical, and no parenting time to the decedent.
Okay. All right. And so again, do you think Miss Campbell's a user of drugs, or no, that's not an issue? It's her being permissive of her daughter's use is your concern?
I don't want to make accusations that I can't prove, but I just don't like the fact that that still happened under that roof with my children there. Whether she was there or not, it's still her home. And
Okay. Well.
May I
Okay,
be
so let
heard
me
on
ask-
that?
I'm going to ask Miss Campbell, your client. So,
Okay.
Miss Campbell, do you want to
Yes.
respond? This is your opportunity. That Mr.
Yes, I
Hummel,
would
one of the
like to.
reasons he wants to deny parenting time is he thinks you were permissive of your daughter's drug use. Do you want to comment on
Okay.
that? And again, you have my empathy and sympathy as well. It's hard when we're in court talking bluntly about your daughter, and I know that's not fun, but unfortunately, that's the reality today. But I just want to give you my condolences. And Miss Campbell, this is your opportunity to tell me your thoughts and your response.
Okay, thank you. My daughter was in 12th grade math and 9th grade. She was in softball, volleyball, music, and culinary arts. She just got around the wrong person, obviously, that introduced her to drugs. I'm a high-low driver at the Ford plant since 1996. I have spent and got my insurance company even to spend $15,000 to put her into a rehab in Arizona in 2016. I put her in multiple rehabs. And for the first 2 years and 3 years of those boys' life, they lived here. I paid everything, and Evan lived here also for the majority of the time. I didn't allow any drugs. And she only overdosed once here. And when she did, it was at 2 a.m. on my birthday, March 12th, and I am the one that notified Evan and his girlfriend so they could come get the kids so I could put her into a rehab. I never condoned or allowed anything. And Evan lived here also for the majority of the time, but they moved out February 1st, 2019 until August 2019, only 6 months, they all moved out because she was working 8 months pregnant with her twins. And he was having relations with her sister downstairs where my room is like a bungalow upstairs. And it's like a separate, like almost like a spiral staircase, but it has, like a fireplace, and it's my own separate room. So I didn't know what was going on down there while Coda was sleeping, that he was having relations with my other daughter. So when my other daughter, Shauna, that passed, found out, they moved out to a apartment 5 minutes away, which I furnished. I would drop off food twice a week to them. And then when I got a call, I was on my way over there to babysit. Instead, I got a call saying one of the twins, Alex's twin, Easton, was being rushed to the hospital because he suffocated while she was out looking for a job to help pay those bills, and in the care of Evan. And then he left with his dad, and she came back and to my home with a penniless. I paid for the funeral, I paid for the headstone, I paid for the grave plot. And then they never got divorced because they were never married. And then that day she did overdose one time here. I'm the one that informed them, and I got her into rehab, and I also gave her an eviction notice until she stayed, and if she didn't stay in rehab when she didn't.
Okay. So a lot of tragedy here and a lot of things that raise a lot of feelings. So let me ask this. So Ms. Campbell, clearly you have probably some pretty strong feelings about Mr. Hummel. Have you been expressing those on social media and other places?
No, I'm not even friends with him on the social media. One time I just posted one time that it wasn't fair that I'm not allowed to see my grandchildren because we were so close, and they lived with me for almost the majority of them being 2 and 3 years old. And they can recognize that they love me. We have a great relationship. I did one time for 17 minutes, and that was it. And it wasn't really nothing. It just said that it was unfair that I'm not allowed to see them. And that was one time. And it offended his girlfriend because that's it.
All right. So Mr. Hummel, what was it like when you lived with Ms. Campbell? And guys, I'm going to cut to the chase here.
Oh, Your Honor, I mean,
you
may I
guys
say one thing?
Okay, go ahead, Ms. Howard.
And to Mr. Hummel's point about being in the home where the children's mother had dealt with addiction issues, Ms. Campbell is proposing that the 3 overnights that she's requesting during the summer is at her cabin and not at her residential home, because when we were discussing grandparenting time, he made it clear that it was the home that was the problem. So Ms. Campbell is willing to exercise those overnights at her cabin that won't be at the residence.
Okay. So guys,
can I say one more thing? I'm sorry.
Sure.
Can I say one more thing? I don't have 2 big dogs. I have 3. They're a golden retriever and a Rottweiler, and a English Mastiff is the one that's 140 pounds. Him and his girlfriend brought the boys here, and the dogs were great, even with Alex pulling the English Mastiff's tail. English Mastiffs are very gentle dogs. All my dogs are very well behaved. The Rottweiler was
Did you have these dogs when you guys lived together?
Yes, I had the Rottweiler. Yes. They come over, and they got along great with the boys.
All right. Okay. I got.
Okay, Ms. Campbell.
Gotcha. Okay, guys, I gotcha. So, guys, I'm going to make a point. So, the law presumes initially, that a parent can deny parenting time. Now, you have had a lot of time, Mr. Hummel, Ms. Campbell's had a lot of time with your children. It doesn't sound like she was permissive of the drug use. Now, on the flip side, Ms. Campbell, the grandparent has the heavy lifting here, because if you can't be on social media and bashing a parent, or they're not going to let you have parenting time. You're saying it's one time. I don't know if it was more than that. You guys clearly have hard feelings with each other, but if you guys don't resolve this today, and you don't have to, this is a motion hearing. I have lots of motions. I'm going to refer this for an evidentiary hearing. That means more time, energy, and attorney fees, because Mr. Hummel, Ms. Campbell has a right to try to prove that it's in your children's, against their, emotional well-being, to not have parenting time. On the flip side, Ms. Campbell, and I appreciate your attorney's position, your time is not analogous to a parent. So the kind of schedule you're proposing isn't terrible. So the point I'm making is, guys, is if you don't want to spend more time and money for your attorneys to prepare for an evidentiary hearing and come back, this is the opportunity that you guys could have this done today. Now, you don't have to, but if you want, it's going to be expensive. I'm going to schedule an evidentiary hearing for you guys to either testify on your own behalf or bring witnesses, as whoever you want to bring, or for that. I tend to be an advocate of grandparenting time when a parent has had a lot of time. But again, Ms. Campbell, you got to do the heavy lifting. So whatever you feel about Mr. Hummel, his relationships with family members, anything that's happened, you're going to have to keep that to yourself, because if that comes out, he's not going to want to have parenting time. So, Mr. Hummel, what are your thoughts about what I've had to say? And if you want to talk to your attorney, that's fine. Your attorney's here. But
I
Any thoughts
okay.
of council, what you would like to propose, if anything to
I-
resolve this without a
I
hearing?
already proposed it. I mean, I was willing to give her the third Saturday of every month for
Okay.
from 9 to 6 or 8 to 6, whatever, because she lives about an hour away.
Mhm.
We would give her
Okay.
holiday, let me finish. We would give her holiday parenting time on Christmas Eve, Easter, and even the weekend of Thanksgiving to be agreed upon by the parties, depending upon their celebratory traditions. If we
Okay.
would put it in the order, he wouldn't be unreasonable. Also, all the transportation would be provided by Miss Campbell due to the distance. But sometimes, since she lives in Ann Arbor and he lives over here, weather may play a role, or the holidays may fall on her weekend. We would agree to make up that parenting time if she missed it due to weather or holidays within 2 weeks, whatever it might be. The problem was she wants overnights and he doesn't feel comfortable.
Okay.
I thought was if we agreed to this now, and things go better, and Mr. Hummel disagrees that it's one social media post. He's sent me several. So, but if things would calm down, perhaps in 10 months, he may be willing to let the kids go up to the cottage overnight 3 times, But right now, it's a very tenuous situation where I don't think either party's very happy with the other one. So to start this, she would get some visitation immediately. And I thought that was a good start. And at one point, I thought maybe we were going to come today and have an agreement to that, but apparently not. But, you got 10 months till next summer. Her request for the summer overnights was in June, July, and August. That's a long ways away. If they could get along, he may be willing to let her have some overnights.
What if you guys just made it the third weekend for the day until the summer and then start the overnights in the summer, and then you'd have time to come back if you didn't want that to go into effect?
May I be heard
With
on
that.
that, Your Honor?
Sure.
So, yes, we did go back and forth about that schedule, and Ms. Campbell is open to taking that schedule. The only thing that she is asking for is just during the summer, the overnights at the cabin. And so Ms. Campbell is working to get closer to the schedule that they want. The only thing is that her concern is, since she lives so far, she won't be able to get meaningful time with them. And also there's a whole side of the family who wants to spend time with the children and wants to get acquainted, reacquainted with the children. And so part of her, trying to meet Mr. Hummel halfway was making sure, okay, he doesn't want the children at the house. We'll move it from the house to the cabin, and it'll just be one overnight from Friday evening until Sunday morning. So that's the only thing that is hanging in the balance. And
Okay.
so,
So again,
that
guys.
is about 10 months away. And so we are very
Okay.
close to an agreement. It's just, she just
So
wants to
guys,
be able to do an overnight. Yeah.
so how about you guys just make the overnights go into effect in the summer? You have 10 months in that, Mr. Hummel. You could then come back if the next 10 months don't go well and say, I don't want the overnights to kick into effect, and say, hey, I don't want it to happen. Otherwise, guys, you're heading towards the evidentiary probably.
So can I speak on it?
Yeah, sure.
The only things that I want to stop completely is the abusive text messages I'm receiving from Joni and the social media posts about me. And I'd never felt right to just hand my kids over to somebody that is just mentally abusing me and my family, my mother, my girlfriend.
What kind of things is she saying? What is she saying to you on text or in social media posts?
She's saying that I'm the reason her daughter died. It was my fault.
I never said that.
I have the text messages in my phone. I don't want to argue, but I do have everything saved. Photos of my kids with diaper rashes, bruised feet, mosquito bites on their face. I mean, it goes on and on. Diapers 2 sizes too small on them while they were being watched by Miss Campbell. So
Not me.
Yes, you. Yeah.
maybe Shauna. And my
Okay,
daughter had
so
pictures of them
guys,
on
listen,
my
I'm
Okay,
gonna,
Ms.
phone.
guys,
Campbell,
I'm,
let him speak. Let him
Ms.
speak.
Campbell, I'm gonna make
Okay,
my point again. If you get in a battle of words with Mr. Hummel, you're gonna
that's fine.
lose
Sorry. Fine, I'm
because,
sorry.
it's gonna be hard for the court to find that it's against these children's emotional well-being not to see you if you're constantly getting in arguments with Mr. Hummel. You got the heavy lifting.
Okay.
You can't be getting into it with Mr. Hummel no matter what you think on social media, on text. So Mr. Hummel is saying he doesn't think you're going to be able to do that. You have to do that because your rights are not equivalent to a parent. And the court is not going to find that it's against these children's emotional well-being if you're in a war of words with Mr. Hummel. He doesn't have to put up with that, even if you don't like him.
I have
So
a
we
feeling.
agree that,
Well,
if Ms. Campbell promises to not make any Facebook post or text him anything negatively, that we could work on this schedule and what the referee suggested. And then also, if we need to have them communicate for scheduling purposes through a Family Wizard app or app close, then that's something that we can do to make sure that there is no miscommunication between the parties. And if so, then it will be tracked and we'll know exactly what's going on.
I have a compromise that I can suggest that may resolve
okay.
everything.
All right.
We'll give her the parenting time we agreed to now, the 9 to 6 on the third Saturday of the month. And we review this in May. If everything goes fine in May, we'll give her the overnights for June, July, and August. But I don't want to give her that now and then have to fight to take it away in 10 months. I'd rather set a review date.
All right. So if you guys want to do that, I would permit you to do that. And probably how I would word it is to be reviewed after February of 2024 upon request of either party. So I don't want to just automatically put it on a calendar. Plus, I probably can't put it on my calendar yet because of my computer scheduling. But I would put it on you guys then to call and ask for that appointment, or you guys do a consent order and it never happened. You don't have to call and ask for an appointment. That would be fine with me as well.
That was my thought, that if things go well for the next 6-8 months, I don't think Evan would have a problem. Correct?
Correct. I mean, I just want all the drama to stop. That's it. That's all I've ever wanted. We wouldn't be here today.
Okay. Guys, I'm hoping after today, I mean, Ms. Campbell's heard me. And I'm hoping and her counsel's heard me, and I'm sure counsel understands my points. You guys want to agree on a temporary basis to the third Saturday every month from 9 a.m. to 6 p.m.?
It can even be 8 a.m. if she's concerned about the travel time. I'm not worried about that.
Could we do 8 a.m. to 7? Ms. Campbell, would that make you feel better for commute time?
The reason I just want to say that they weren't, maybe you have pictures of them with I don't know about diapers. That might have been with Shauna, but never in my care. I have taken them to the cabin with a few times, but and it's a family cabin I bought so they can enjoy and grow up and probably inherit it one day and have memories at the cabin, and that's all. And he had no problem with me bringing the boys, and
but their proposal,
Right.
their proposal is that you guys come back prior to the summer to revisit this. If everything goes well, you guys might just do a consent order and not need that hearing, or you come back and make those arguments. And why I put February is you want to get in before the summer. So if you're February, March, that's the time you should probably ask for a hearing, because it takes about 6 weeks to get them scheduled on the calendar. So that's why I put it earlier for the hearing, because you guys got to get it done before the summer.
We're good.
But if you guys want the hearing, otherwise, guys, I'll refer for an evidentiary, and you guys can keep talking and do a consent order if you guys don't want to come to that evidentiary.
Well, can we do that agreement with just having them for the cabin this summer, and if it doesn't work out, then we come back and then just avoid that?
No, he's saying he wants it reviewed. He is not. You guys, the summer's over. It's done. So you're talking almost a year. So he's saying, ma'am, that he wants to see how this goes. And I'll give you guys the permission, the ability within this order to come back upon request of either party after after March 1st of 2024. Or you guys, in the meantime, you guys, everything goes well, everybody's feelings, it has time to settle, and then you guys rebuild some kind of rapport, don't have to be best friends, and you guys do a consent order. But the question, Ms. Campbell, is are you okay with the 8 to 7, the third Saturday of the month, and the holidays is set forth Christmas Eve, Easter, and Thanksgiving per mutual agreement?
Yeah.
Are you sure? Or do you guys want me to just schedule an evidentiary and you guys keep talking and do a consent order with all the provisions you want?
Your Honor, I think what's best, because I feel like I need to talk to my client a little bit more, but I think what we could do is, I think we are very close to an agreement and I believe we can get there, but I would just set it for the hearing for now. And then we can do a
Okay.
consent order. I just want to take some time and speak with her to make sure she
Okay.
understands and wants to agree.
All right. All right.
And
All right, guys.
can
Then go ahead, Ms. Campbell.
I say something? I always
Okay.
thought Evan was a good father. He could swaddle those babies better than me. And what happened to the other twin was an unfortunate accident, and exactly what me and my daughter told CPS. And I do apologize. There was only one Facebook, and I apologized and took it off. And I always thought that he was, even when he lived here, he was very respectful, and he was really good with the boys. And it was
Okay.
just that's all I want to say. It was an unfortunate accident.
Okay. All right, guys. And my recommendation is that the matter of grandparenting time is referred to the front of the court for a referee evidentiary hearing. Do you guys want to make that a consent order, or do you guys want 21 days to object to it? It's up to you guys.
We can do a consent order.
Any thoughts, Mr. Beretta, consent to the evidentiary? Or no?
The only one thing I'd worry about is I'm going to be gone. I don't want it scheduled when I'm gone. I'm gone the last week of October, which is about 6 weeks away. So,
well, I can put in the order. I'll put in here 2 hearings should be scheduled. What's the block you
after
want?
November 1st. After
Okay,
November
I'll put hearing to take place after November 1st. Guys, it's usually at least 6 weeks out anyways on our calendars. That's gonna be, guys, that's 6 weeks anyways. There's no way you guys won't be in October anyways, but I'll just put after November 1st. And guys, it would have been, okay, we'll put hearing to be scheduled after November 1st. And just as an aside, I'm gone the month of October as well for surgery. Not that you guys, that's important for you guys, but it means if it was in October, you won't get me. You would get somebody else. So.
Okay, Your Honor, we just have to make that November 6th because I have my anniversary vacation first week of November, but that's it. I'm done.
Okay, well, I'll put hearing after November 6th. All right. Does that work for everybody now? Or
Yes, it does.
You have my permission to sign the order.
Okay. All right. So guys, a consent just means you waive the right to object to the hearing, your attorneys are saying, and I'm going to recommend it, and I'm pretty sure the judge would uphold it, not that I speak for her. So everybody's okay that this is a consent order, evidentiary hearing to be scheduled after November 6th. And guys, how you can resolve this before that. I just ask if counsels, if you guys resolve this, please call my office so we can take it off the calendar if it's on my calendar. It might be with somebody else, but if it's on mine, just let us know so I can open up that date for something else. Okay?
Yes.
Is everybody okay if we email you guys a copy of this order?
Yes.
No
sir.
problem.
All right. So guys, please think about what I said. Your attorneys heard me. They understand. You guys have worked hard. You guys have came in here with a lot of movement forward. I appreciate that. It's not exactly what got you there, but I'm confident, hopefully, that you guys will not need that hearing. Okay, guys, with that, it's going to conclude this hearing. Please motion here that I shouldn't say benefits, but it doesn't harm the plaintiff in any way, the request here. And guys, just so we know what we're talking about for the record, we're here today on the receiver's request for compensation and reimbursement of fees expended as the court-appointed receiver for sale of the marital home in this matter. And counsel, again, are you okay if Mr. Haddad proceeds with his request?
Yes.
Okay, Mr. Haddad, if you'd like to proceed.
Thank you, Mr. Referee. I was assigned by the court last July for purposes of marketing and selling the former marital residence. This was a post-judgment request that one of the parties made, and the court obliged. Once I received the assignment, I inspected the property. I consulted with a number of local real estate agents, and we got the home listed for sale. There were a number of challenges regarding marketing this property. It's a corner lot with a smaller detached garage. Both of those things typically put off a number of potential buyers. But in any case, we did receive a number of offers. During the inspection process, it was determined that there was some mildew or possibly mold in the attic area, and that frightened off a number of buyers. But in any event, we got the property sold, and the closing was scheduled last December of 2022. On the eve of that closing, Mark Steiner, who was still in possession of the property at the time, suffered a horrible gunshot injury, and while he was within the home. As a result of that, there was a fair amount of blood and tissue and biological matter that was spread throughout the home as a result of the bullet injury, and the home was deemed a biohazard. So that December closing didn't happen. And then I was called upon by necessity of dealing with the cleanup, the insurance company, and other issues, trying to get this place cleaned up so it could be resold. We did that. We had the property sold again. The closing was scheduled in July of this year. But at the final walkthrough, the seller balked because the home had not been completely emptied. I'll say it that way. Rather than lose the deal, I gave the buyer a concession of $1,500, which seemed to satisfy them, and then they would be responsible for the balance of the removal of material that had been left behind. When all is said and done, I expended approximately 26 hours over the past year getting this property sold. My expenses are less than $100. I've attached my contemporaneous timesheets to the motion. I'm requesting receiver compensation in the amount of $7,797.65. That would leave, if that's granted, that would leave a balance of approximately 104, rounded up to $105,000 available for distribution. I would be obliged to distribute that money according to the court's directive.
All right. And Mr. Steiner, any thoughts? So, and guys, I do note that the referral order appointing the receiver did indicate that Mr. Steiner would be responsible for the costs of the receiver.
Yes.
And what is the provisions, guys, in the judgment? And I'm sorry, Mr. Steiner, I asked you a question. I kept talking here. What is the provision and what happens to the proceeds after Mr. Steiner pays plaintiff $21,000 and so much change? Does he get the remainder of that per the judgment?
Yes, he does.
All
Yes.
right. So, Mr. Steiner, this is your opportunity to say anything to me you want. If you have questions of counsel, what are your thoughts? So, counsel would like to take his fees out of that, pay the $21,000 per the judgment, which is what resulted in the sale of the house, and then you get the remainder per the judgment.
That's my understanding of it.
Okay, so you have no objection to Mr. Haddad's request or the disbursement of the proceeds?
No.
All right, so I'm going to indicate, and so guys, just so you know, I can do today, I'm a referee, not a judge. I can do a recommended order that gives you 21 days to object. Or if you feel you totally understand, you can waive the right to object and make this a consent order. So Mr. Steiner, this is mostly aimed if you have any questions. So if you're in agreement and want to waive the right to object and say to the judge, hey, I don't like what the referee did, we can do a consent order that indicates the receiver, Mr. Haddad's motion is granted. He shall be able to withdraw his fees from the escrow account, pay the plaintiff her payment pursuant to the judgment, and then you get the remainder per the judgment. So he's going to take his fees and effectuate the judgment.
Right.
Are you okay with Mr. Steiner?
I'm perfectly fine with that.
Okay. And Mr. Haddad, is there a certain way you want me to term this? Maybe more astute than me. Do you just want me to indicate one, receiver's motion is granted and he may withdraw his fees as set forth in the motion from the escrow account? Just, and then effectuate the judgments and that plaintiff receives a payment and the remainder goes to defendant? Or just I
Yes,
can say effectuate the judgment?
That's fine, but I'm not privy to the judgment or anything that happened prior
Okay.
to the judgment. So perhaps we can do the arithmetic this morning and just
Okay.
the order can reflect the numbers. That would make my life easier, really.
And there's nothing else that Mr. Steiner had other than the payment of the 21,000. There's nothing else he owes, correct?
No,
Or-
Ms.
No.
Tice, what is that exact figure, if you wouldn't mind?
it is 21,500. Although she has incurred a great deal of fees because of the actions of Mr. Steiner. I do want the record to reflect that Mr. Haddad
Okay.
did an amazing job, above and beyond
Okay.
really any receiver I've ever dealt with before.
Well, thank you, counsel.
The
Okay.
responsibility.
Well, it makes, okay. But I didn't mean to cut you off. It makes it, well, it feels good since I appointed Mr. Haddad. It makes the court very happy to hear that. And Mr. Steiner, do you have any questions at all?
No, I don't.
Okay. And I'm sorry for your injury, sir. I hope you're back on the mend and feeling well. And so
Ms.
guys, we're going
Tice?
to indicate that
Thank you.
I'm going to put one, the receiver's motion is granted and he may withdraw his fees as set forth in the amount as set forth in his motion from his IOTA account. And it's 21,500 paid to plaintiff, correct? Per the judgment?
Correct.
Correct.
I'm going to put two. The receiver shall disperse $21,500 to plaintiff Dawn Steiner pursuant to the judgment of divorce. And three, the remainder of the IOTA fund shall be paid out to defendant Mark Steiner per the judgment. Is a legal proceeding today. Does that sound okay, everybody?
No.
So, Mr. All right, and we're here today on defendant's motion regarding parenting time. And Mr. Lark, just so you know, once counsel's done, you'll be given a full opportunity to respond, okay?
Okay.
All right, counsel, if you'd like to proceed.
Thank you, Your Honor. Just as way as a brief background, these parties have never been married and they have one minor child. She is currently 2 years old. They recently entered a judgment earlier this year in April regarding parenting time, custody, and paternity. The parties share joint legal custody of their daughter, but physical custody is vested with defendant. Pursuant to that judgment, plaintiff was awarded a graduated parenting time schedule, which initially began with supervised visits at Phoenix House twice a week. Upon his successful completion of each step, he was eventually awarded alternating weekends from Friday evening to Sunday evening. Parties are also required to communicate exclusively through app close. Now, since entry of that judgment, we believe there has been a significant change in circumstances warranting defendant's request for modification of parenting time. Specifically, during a recent parenting time exchange in a Foot Locker parking lot, Mr. Lark physically assaulted Miss Sutton in the presence of the minor child. Mr. Lark was in defendant's car. She had asked him to leave. He exited the vehicle, but left the passenger door open. So Miss Sutton had exited her vehicle to shut that passenger door. And when she exited her vehicle, Mr. Lark approached her, threw a bag of clothes in her face, hit her in the face, busting her lip, hit her again in the jaw. And after she began to fight back, he threw her on the ground of the parking lot, pinned her there, and threatened that if the minor child weren't present, he would beat her up, which is alarming considering the minor child was in the car just a few feet away. And so it's unknown how far he would have taken that assault if she weren't there. Ms. Sutton contacted the police immediately, who arrived. She filed her report. Mr. Lark has been charged with domestic violence and there is a warrant issued for his arrest. But at this time, I don't believe he's been arrested or arraigned on that charge. The next issue, Your Honor, is during Mr. Lark's parenting time, he's completely denying Ms. Sutton any reasonable phone contact with the minor child. For instance, during that same overnight weekend, Ms. Sutton had given the minor child her iPad, which she's done before. The minor child's very savvy with her iPad. She can call her mom, knows how to FaceTime her. Mr. Lark did not let her take it, but the parties did agree that Ms. Sutton would be able to contact the daughter through Mr. Lark's phone. However, as his parenting time progressed, he blocked Ms. Sutton's ability to make any phone calls via app close, which they are required to use, and ignored all of her messages, did not let her talk to the baby whatsoever. The denial of phone contact, we believe, is unreasonable considering the child's age, and she spent the majority of her very young life with her mother. And then the final issue, Your Honor, is we don't have any idea where Mr. Lark is living or exercising his parenting time. The last provided address on Kaufman, we've discovered that house was sold earlier this month on September 5th. And Mr. Lark has refused to confirm his address. And during his first overnight with the minor child, Miss Sutton was FaceTiming her, and she could see that they were in a hotel room. So we have no idea where he's living, where he's exercising his parenting time at all. In conclusion, we are seeking that plaintiff's parenting time revert to the supervised parenting time at Phoenix House. If and when it returns to unsupervised parenting time, we would ask for reasonable phone contact with the minor child. And we really do need proof of his current address. And then finally, we would like to request attorney's fees for having to file and argue the instant motion.
All right. And has there been any parenting time since September 3rd, which is the date of this alleged incident?
Yes, Your Honor, the parties have been exchanging the minor child at a police station.
Okay. So there's been 2 alternate weekends since this happened that he's exercised?
I believe.
And Miss Sutton, you said 1.
Yes, 1.
And is there a no contact bond right now issued, or does it permit for parenting time exchanges from Judge Galen and East Point?
I don't think he's been arraigned yet, Your Honor, so I don't think there's anything in place.
So there wasn't a no contact order issued with the charge, or that happens after arraignment?
I believe it happens after the arraignment, but I don't think there's anything in place right now.
All right. And Mr. Lark, do you realize that you have a warrant out there for your arrest?
No, because I spoke with the officer. He called me on the telephone. He asked me what happened, and he never said anything. I had a warrant or I needed to turn myself in or anything like that.
Well, the police at the initial, are you talking initially on September 3rd, or you called the police department recently?
This was after September 3rd. The incident took place September 3rd, but Ms. Sutton didn't file this complaint until 5 days later on September 8th.
Okay. But so just so you know, if I can't give legal advice, but you may want to call the East Point District Court and say, hey, do I have a warrant?
Yeah.
You can arrange to walk. They probably allow walk-ins, and if you do that, they probably, then you don't potentially get picked up and have to wait in jail a day or 2 to get out. If you do it voluntarily, you probably get I can't say for sure, but it usually bodes better for you to take care of that. I'll leave it.
Yeah, I was going to do a walk-in. I just received this paperwork on Friday. I didn't because I moved.
All right, so you can. Address. All right. So have you moved? Have you updated your address with the front of the court?
No, not yet. I just officially moved on September 12th.
Do you want me to give your address now so we can update it for our records?
Yes.
Okay. And what's your address now?
And we don't believe there's sufficient room for Mr. Lark to be residing there, considering the amount of people that already live there, and the size of the home.
No one lives there but my mother and my sister and me.
Okay. All right. And so, sir, you're not living anywhere else. That's where you took your child for your weekend recently?
Yes.
Okay. And just guys realize this is for everyone. You got to keep the front of the court advised of your address at all times, or you potentially will miss getting notice of something or a hearing, and that generally can go bad, especially if it's an enforcement hearing. You end up with a warrant, then you end up with warrants out there you don't know about potentially if you miss a enforcement hearing. So you always want to keep this up to date. And has everybody got their emails and phone numbers up to date?
Yes.
All right. Yes. So let me ask this, the counselor, Ms. Sutton, if you guys continue the parenting time schedule and he had his weekend and you already did that, why should I not just continue that with somebody assisting with exchanges or at the police department? Why should I take him all the way back down to 2 hours?
Your Honor, during the altercation, there was another individual present. Mr. Lark's sister was there, yet he still physically assaulted Miss Sutton. I'm sorry, I'm not done. Mr. Lark.
Guys, just a second, Mr. Lark. I know, Mr. Lark, you haven't had much opportunity yet, but go ahead, Consul. Mr. Lark hasn't had much time to talk yet.
Thank you. Despite the presence of that other individual, he continued to physically assault Miss Sutton, and threatened that he would have beaten her up further if the minor child weren't present, but yet the minor child was present. So
I got you, but then why did Miss Sutton allow a weekend? Why did she effectuate a weekend of parenting? So let me say this: these allegations are serious, and I'm not trying to minimize them. I'm just trying to put in the context of these allegations. Parenting time was effectuated thereafter. So now there's a bit of a tug of war because I have serious allegations, but now I have a weekend exercised with exchanges at a police department. So I'm like, why go forward and do that if you're alleging he's this dangerous guy? Why do a weekend when you're, and now that's the situation he's exercised post incident?
Yeah, I understand, Your Honor. Miss Sutton was very concerned. She immediately called the police. She contacted her attorney. We filed our motion, and just to comply with their current parenting time order, as she didn't want to, violate the order, the best alternative she could come up with was exchanging at the police station. But we do believe that there is a, reason to modify the parenting time.
All right. So ma'am, and so Mr. Lark, this is your opportunity to tell me whatever you want to tell me. Do you want to comment on these, or you have pending charges? So I don't know what you want to tell me, anything, or what's your thoughts about everything?
Yes. First off, Ms. Sutton's allegations are false. That's not what happened. My sister was there as a witness, and she's seen everything. Prior to me even taking my daughter and exchanging her with Ms. Sutton, Ms. Sutton has been harassing me. This is not the first time Ms. Sutton has harassed me with during my personal time with my daughter. She harasses me, she demands me to talk to my daughter, and, she tells me how much she hates me. She curses, using profanity in front of my daughter, all because, she still wants things to go her way. And all I ask Ms. Sutton is, to respect me, and I respect her, and we can do the best thing for our daughter. I don't mind her talking to our daughter while she's with me. It's just how she go about it. She calls my personal phone number, and our parenting time, it strictly says we should only use the app to communicate, and use our personal numbers for emergencies only. But as far as those allegations she made for me physically assaulting her, that's not what happened. Ms. Sutton threw objects at me while I was giving her my daughter, while we were exchanging my daughter. She threw objects at me. Then she threatened me that she would do what she would do to me. That's when she got out the car. Yeah, I threw the clothes at Ms. Sutton, but Ms. Sutton threw objects at me first. I threw the clothes at her.
How did she end up with a busted lip?
Yeah, that's when she got out the car. After she threatened me and she got out the car, I got in defense mode. I never swung or hit her. I just put my arm at arm's length to stop her from trying to hit me. That's when we became to tussle, and she ripped my shirt. And I didn't throw her on the ground. I slowly picked Ms. Sutton on the ground so I could try to walk away. And she got up and still ran toward me trying to hit me. I was trying to walk away from the whole incident. Ms. Sutton studied.
So you just gently placed her on the ground.
Yes, I didn't throw her on the ground. I was trying to defuse the whole situation. Ms. Sutton provoked me. It was premeditated on her end. She provoked me from the.
So you thought she wanted to provoke you in a physical altercation so she could have you arrested? You think she's that calculated?
That's exactly
all right,
Miss Sutton.
I'm going to let her comment. Ms. Sutton, is there anything you want to add to this dialogue?
Yes, I pulled up to get her. He denied me access as this was her first overnight weekend, and he always.
It was not her first overnight weekend.
Hey, Mr. Lark, Mr. Lark, one at a time. She's going to make her point, and you'll get to talk again. Guys, we won't get anywhere if you guys interrupt each other. So I know you have a lot to say, but let her make her point, whether you agree with it or not, and then I'll give you another opportunity to respond. Okay.
Okay.
Go ahead, Ms. Sutton.
So the 1st through the 3rd was his first overnight weekend. Prior to that, the graduated order was he had 1 day a week to spend a night. And then he would rotate the other day. He would get 12 to 8. So she spent the night a total of 4 times before that. 1 week on, 1 week off. This was her first time staying overnight for Friday, Saturday, to Sunday. So prior to this, he let her take her iPad the first time. And then it died. And even then I was calling her, throughout the day. I FaceTimed her and I was calling her. I texted him through the app and said, hey, can you have her call me back? He ignored because he doesn't look at the app all the time because he responds late, delayed, and everything. So I texted his phone and said, can you have her call me back, please? Then he told me I don't have to make sure she answers her iPad for you. I'm not obligated to make sure she speaks to you when you're at my time. You don't have the privilege to speak to her at my time. So that has happened. The second time you let her take the iPad, which is when I spoke to her and she was at a hotel room. And even then, I don't even think he stayed a night there because I asked her, where's her dad? And his daughter was there too, his other daughter, because he has 3 other kids. So his other daughter was there and she said, Daddy's gone. And he even said the next.
How old are they?
Amelia is 4. She'll be 5 next month. And then the other one,
the other children,
a newborn, and I think in May. And then he has I think his son is 9 or 10.
So who was talking to you on the phone? The 4-year-old?
Amelia, the 4-year-old, with my 2-year-old, the 4-year-old. And I said, where's Daddy? And they said, gone, which, I can't control if he's there or not. That's, this is his second time getting her, this is his second time getting her. And the next day when he was supposed to bring her back at 12, he's late because he's been late plenty of times, which I've allowed because I'm thinking that the common goal is, just Lamore's time with him. And
right. So other than the iPad, do you want to respond to his allegations that you are always yelling at him with profanities and that you assaulted him and he was defending himself?
I did curse at him the third time because he had let her take her iPad the first 2 times he spent the night. The third time he said, "You don't need to speak to her. It's one day. What do you need to call her for?" And I said, "Don't your other kids, speak to their parents when they're not with their mom or dad?" And he said, "No, da, da, da." He just was yelling like, "No, we are too busy enjoying ourselves, making memories, everything." I was like, I did curse and said, "You're so effing ugly. That is very ugly of you to not allow me to speak to my daughter when she's with you because you feel like this is your time." But I have offered plenty of times, or at least twice to him, here's her email to her iPad. You can call whenever.
Do you guys tend to dial when you guys talk to each other? Do you tend to use profanities when you guys are talking to each other?
No, we never really, no. So I was just upset and hurt. I mean, because this is my only child and I'm not used to not speaking to her. And, I just want to be able to say good night or, how are you doing? Because she can't talk. He lives at the house with multiple kids. He lives with his girlfriend. She has her own son. Like, where does she sleep? I don't know.
And let me ask this: what is your relationship with his sister and his mom? Has that been bad? Has that been okay? What has that dynamic been?
I haven't spoken to his mother in over a year, since last January. So I don't speak to her. The sister, I haven't spoken to her since last year either because she got upset, or earlier this year because she got upset. Well, she didn't get upset. We just don't get along. But I've never had yelling. Or, I've never had that.
Okay. So they've always been, you've had a respectful relationship with them. They've never got into it with you.
No.
And they've been the same, or you say no?
They've just been negligent. When he's not around for 10 months, they didn't call. I have to,
but so here's the point I'm getting to. So if he's living with his mom and his sister, does your child love grandma or no grandma?
I don't know, because I have only experienced her with her before she was 1 year old, when I was taking her to see his mother, when he wasn't around for 5 months and then 10 months.
And that went okay, but she was always respectful when you took your daughter to see
okay.
her?
Yeah, she's we've never argued.
So the point I'm making is do you think she's a positive influence that if he's living with her, that makes you feel more secure if your daughter goes there?
Can I say, Judge, I've asked him his address after the altercation because I called my attorney and said, hey, this is what just happened this weekend. Do I have to still send her on Wednesday? She said, well, Janae, you have to follow the order. So with that being said, I asked him in the text, I said, do you still live at this address? He ignored that. And I told him the instructions to receive her from the police station when Angela informed me that, Janae, you do have to follow the order unless you feel that Lamore is in imminent danger. And I'm not going to go that far to say that this man is going to harm my child. I did not say that. That's not how I.
Well, okay. So let me ask this question. So domestic violence is not okay. I'm not making a finding that it happened or didn't, but if it did, that's not okay. Do you think that somehow he would harm your child?
I don't believe that he would harm my child. I don't believe that at this time. No.
Okay. Okay. So, and she knows her dad. When she sees him, she seems happy to see him.
She knows him. She's excited to see him, now that they finally built a relationship.
And Mr. Lark, what are the ages of your other children and what's your schedule with them? How often do you see your other kids?
I see my 4-year-old and my newborn, my 4-month-old. I see them just about every day. Same thing with my 10-year-old. He's in school. He lives with his mom, but I see him every day because he plays football. I take him to football practice and football games, and all my other kids, we all go when we have football games as well.
All right. And let me ask this, Ms. Sutton. Okay. And Ms. Sutton, tell me, is this alleged incident, is this the only time that happened, or are you alleging that throughout your relationship there were issues?
No, when Lamore was maybe 5 or 6 months, he pushed me into a wall when he was trying to take her, and I said, you can't, like she's not going. He pushed me into a wall twice while holding the wall.
I never pushed her. If I pushed her, she would have done the same thing she just did. She would have went and filed a complaint, but she did. I never pushed her. She was attacking me.
So let me ask it. So guys, and again, I'm going to remind you guys when each other's talking, please don't interrupt. So Mr. Lark, do you think today she just decided to tell me out of the blue and make it up that she says when my child was 5 months old, he pushed me? That just came to her to lie and tell me today?
she made those allegations before, but again, it was me. It was her coming at me. I was defending myself. She's always trying to provoke. She's always done this. You know, the only difference is then she didn't go and make a claim because she know those allegations that she's making right now is false. Or maybe she feel like, well, I didn't have any custody of my daughter. Right now, she feel like she want to go make a complaint because I have some type of custody of my daughter, which she don't want me to have. But if you really want the best for your daughter, you won't be trying to provoke me and come up with these allegations when I'm always trying to talk to you before we get a better understanding of
I thought you defended yourself. Now you say you were provoked.
No, all right, I was provoked, but I defended myself. Of course I defended myself. You know what I'm saying? She provoked, like she would do things like try to attack me or throw things at me, you know, and then I would have to be in defense mode. I don't want to be in defense mode, you know, because it's all irrelevant. I don't want to, you know, have to go through this with me. I told me something this over text. I even text her like, hey, listen, I don't want to, you know, want you to be mad at me. I don't want you to hate me. If you do, then that's fine. I don't care, you know, but when it comes to our daughter, let's try to do the best for her, you know, try to put your feelings to the side. You know, Miss doesn't have this personal vendetta against me, maybe because I don't want to be romantically involved with her. You know, because if you really care about the best thing for our daughter, and you see that our daughter is excited and she loves me and she wants me to be a part of her life, you know, you would just roll with that and try to get an understanding with me and her of that. You know, and anything else wouldn't matter. What happened 4 years ago or 5 years.
So listen. Okay, I'm listening. But so on September 3rd, there wasn't a disagreement over candy, her taking candy away from your daughter in the car seat.
Yes, he took the candy from my daughter. I don't think I asked him. I say because I took it from my other daughter. My other daughter was in the car at the time, you know, and Lamora, which is the daughter me and Miss Sutton share, she was crying because she didn't want to go with her mother. You know, this is a continuous thing. She's been doing this for the last 4 exchanges.
Well,
but anyway, I gave her candy thinking it would stop her from crying. You know, her mom took the candy from her and gave her a cup or something, and she threw the candy in her front seat. I say, well, could you give me the candy back, please? You know, I'll just give it back to my other daughter, you know, because she's crying at this time now, you know, and Miss Sutton didn't say anything. I'm just standing at the car. I asked her again, you know, could you please give me back the candy? She didn't say anything. At this time, she was strapping my daughter in the car seat. And when she's done strapping in the car seat, you know, I was waiting patiently while she was strapping in the car seat. She turned around and said, close my door. I said, well, could you please give me the candy back? She didn't say anything. She took the candy and something else. I don't know what it was, and it struck me and hit me. And then at this time, I'm like, why would you do that? So that's when I took the clothes and I threw the clothes at her. It was a bag of clothes with like a shirt or something that my daughter had, a shirt and some pants. And then she tried to hit me back with it and tried to punch me. And then she said she threatened me and said what she would do to me. That's when she got out the car and came around my way. At this point, that's when I became defensive. But I never strike the blow or try to hit me. But I only tried to put my hands.
Okay, I've heard, guys. I've heard it. So how did this exchange go? What police department did you guys utilize when you guys did the last weekend?
I called the East Point Police Department.
Yeah. Okay. No, but how did you guys do your last parenting time exchange?
Oh, at the East Point Police Department. And I informed him to whoever gets there first, go inside, wait. And then, you know, whoever has the more, I bring her and I just open the door, let her in. Then I go to my car and he waits till I leave and then he can come out. So that we, you know.
All right. How did this exchange go? What police department did you guys utilize when you guys did the last weekend?
I called the East Point Police Department.
Yeah. Okay. No, but how did you guys do your last parenting time exchange?
Oh, at the East Point Police Department. And I informed him to whoever gets there first, go inside, wait. And then, you know, whoever has the more, I bring her and I just open the door, let her in. Then I go to my car and he waits till I leave and then he can come out. So that we, you know.
All right. All right.
This never been an issue before. This is just something that she just tried to find a way to.
Well, all I know is, guys, listen, all I know is the police seem to think something happened and you have a charge pending in it. And I would suggest if you didn't know about that you contact the East Point District Court and find out what you need to do to take care of that or get this thing rolling. Otherwise, you could be picked up at any time by police on a warrant. Go ahead. I was going to say, if you have a warrant, next time you do a parenting time exchange at East Point, they're going to pick you up.
May I say speak, Your Honor? I asked him that when I called. So that incident happened on the Sunday. Throughout that week, the detective called on Monday. I gave him my statement. however long it took for him to get Mr. Lark's statement. That following Monday, I called to follow up. Well, I called on Thursday. They didn't answer the detective. I called on Monday.
Yeah, but so where are we going with this, Ms.
I was just saying, I was informed last week, Monday, that the prosecutor signed.
Okay, well, guys, okay, wherever the warrant is, he needs to call and take care of it. He's got
No, I was just saying, because I went into the police station, I asked, well, if he has a warrant, he's coming in to exchange my child, is he able to be arrested? And they said no, that he has to get police contact or turn himself in, because maybe he doesn't know.
Okay, all right, okay, then I stand corrected. Then they're not going to pick him up. So it's intriguing to me that he's in the presence of a police officer with a warrant.
That's what I'm the irony of it all.
Okay, all right.
And
all right, but
I want to say one more, if I'm able to, Your Honor, not to go back and forth.
Go ahead.
The fact that Mr. Lark is blatantly lying is just disturbing. He continues to. When he pushed me into the wall twice, this is documented in our custody hearing. I have the text message where he apologized for putting his hands on me. So I don't know why he's lying now when that has already been stated.
So why didn't you follow
and I didn't call
Mr. Lark, stop. Mr. Lark, do not interrupt. Let her talk.
And I didn't call the police because when he pushed me the first time, I stepped back and I said, can you just give me my baby? I was reaching for my child. And he said, I don't know if I'm allowed to cuss. Am I allowed? Or he just said,
if you're in court, you can say whatever was said.
Okay, he said, he pushed me into the wall. He said, my nigga, get the fuck back. That's what he told me. And that was my first time seeing him get really big. And I said, can you, I stepped back and I said, can you just put her down? He said, I'll take her right now. You won't get her. I'll take her right now. And da-da-da-da. And I just said, can you just please put her down? You can leave my house. And he was upset. He was upset.
So in this recent incident, how did you get your lip split? Was that by his arm, or how did that happen?
When I took the candy from my daughter, he continued to say, "Why she can't have?" He never said, "Please, why she can't have the candy? Why she can't have the candy?" I ignored him because I can see you're getting hostile. You've already said goodbye. I don't know why you're still standing.
So so he hit you with the closed hand, open hand?
I got out the car, he threw the bag of clothes, and I just know his hand, he hit me in my mouth, and my teeth was sore. Then next thing I'm hitting back because now you hit me. Then he hit my jaw, and next thing you know, I'm on the ground. And I did pull his shirt because when I'm going on the ground, I'm just grabbing and I ripped his shirt. Have you guys had a hitting incident in the past, or this is the only time you've ever had this kind of contact? Besides him pushing me into the wall when she was in 2021, this is only the second time. So that was him pushing me a wall twice. Okay. And I just
all right. So guys, all right. So guys, I'm a referee, not a judge. I'm going to make a recommendation. It's going to be the temporary order of the court. You both will have 21 days to object. If no one objects within 21 days, this stays the order of the court. We're going to send you a copy of this order and the objection procedure. I haven't said the order yet, but I'm going to momentarily. If you guys have any questions on how to object, you're welcome to call my office. We can't give legal advice, but we can help you procedurally make sure you can get the hearing. When I say hearing, if you object, you'll get a hearing before the judge herself, the Honorable Terry Lynn Dennings, and she'll decide if she agrees with my decision or not. And her decision as the judge is the final say. Again, you have 21 days to object. If you don't object within 21 days, this just automatically stays the order. All right. So again, this court does not in any way condone physical violence. However, based on your testimony, you don't think he would ever injure your child. He's exercising parenting time with his other children. I am going to keep parenting time in place. I'm going to indicate 1, parenting time exchanges shall occur at the East Point Police Department pursuant to the current parenting time schedule. Now, here's a caveat. If Judge Galen says no contact whatsoever, so when you guys get in front of Judge Galen, you have to decide whether you want her to carve out an exception for parenting time exchanges at the East Point Police or not. If she bars any contact between you guys, I'm going to put, should the judge issue a no contact bond that does not permit contact at parenting time exchanges, you guys will have to use the mutually agreed upon third party to help do the exchange. That's for you, Mr. Lark. So I'm just saying, if you get in front of the judge, say, can we keep effectuating parenting time exchanges at East Point? If Judge Galen says no, there's a complete bar of contact between the two of you. You're going to have to agree to someone else to go and do the parenting time exchange at the police department so you don't violate your bond. You don't have a bond yet, but if you do, and there's no provision to allow for parenting time exchanges, you got to have a third party help you out. So you guys will have to mutually agree to that. I'm going to indicate that 2, a parental cooperation order shall enter, which says as follows. Both parties must communicate respectfully and courteously with each other regarding their minor child. And your child's young right now, but this provision will apply later. Any parent who has knowledge of any school or sporting activity or event should give adequate notice to the other party so they both have an opportunity to attend. Both parties have a duty to promote a good relationship between the child and the other parent. Neither parent may speak badly about the other parent in the presence of the child, and must insist that their family and friends do not insult the absent parent in the presence of their child. That parties are prohibited from fighting or arguing with each other in the presence of the child. When your child is older, neither parent shall question the child regarding the other parent. Neither party shall encourage the child to complain about the other parent, and both parents should support the decisions regarding discipline and rules while the child's in their respective care. So guys, that's what the parental cooperation order. I'm going to put 3, the matter of parenting time is referred for referee evidentiary hearing. If you guys do a consent order, you can contact counsel and she can help you prepare a consent order. If you don't want to go forward with that hearing, that's the only thing that would cancel that hearing. And Ms. Sutton, you have a question?
Are you able to am I able to speak to my daughter through the app, call her still? Like, I want to be able to.
Well, are you guys using app close?
We
Is that what you're using?
He disabled the calls.
All right, so let me put this. I'm going to put.
I
wasn't done with my rec. You got to let me finish my rec before you start asking me questions. I might have been getting there, but you didn't let me get there. All right, so what are we on for? All right. So plaintiff shall permit, and whoops, I want to make sure. And sir, you're a plaintiff, Ms. Sutton, you're a defendant on the case, correct?
Correct, Your Honor.
All right. Okay, just want to make sure. If I said that wrong, my staff will correct that on the order. So if I mischaracterize either party, I'll indicate we'll correct that. All right. So I'm going to indicate defendant shall have contact with the minor child virtually through AppClose or another application each Saturday with the party's minor child at 7 p.m. Does that work? 6 p.m., 7 p.m. during plaintiff's parenting time. So whatever means you guys have to make that work, make it work. You guys have done it in the past, so you should be able to do it now. All right. I'm going to indicate further, neither party shall use profanity in their communications, nor shall either party disparage each other on social media. All right. All right, guys. And I'm going to indicate that in counsel, you said there's a request for attorney fees. What's your request?
$1,500, Your Honor.
All right. So I'm going to indicate next, defendant shall reimburse plaintiff's attorney $500 as contribution towards attorney fees as a result of this motion today.
Your Honor,
all right.
if I could.
Within 21 days. Go ahead.
I'm sorry. I just wanted to add one thing. If we could have actual hard proof of Mr. Lark's current address, he's lied regarding his previous addresses, so we would just like some sort of proof where he's living.
Well, I don't know what kind of proof do you want?
If he hasn't updated, his ID or utility bill, something.
I'll indicate here that both parties shall keep each other apprised of their current address and whereabouts.
Thank you.
When exercising time with the minor child. So guys, you guys just have to keep the court and each other advised of your current address, which is part of the current order already. But I'm not going to require exchange of utility bills or anything like that. Okay.
Thank you.
All right, guys. So you guys have 21 days to object. Realize objecting is your right under the law. I do not get upset and the judge doesn't get upset if you don't agree with me. That is your right. So if you want that hearing and you don't like this order, guys, you both will have 21 days to object and ask for a hearing before Judge Dennings. And Judge Dennings will decide she agrees with me or wants to change all or part of my order, and her decision as the judge is the final say. Okay.
Okay.
And you guys know when the next weekend's supposed to be?
This weekend.
And sir, you want your weekend this weekend, your alternate weekend?
Yes, sir.
All right. So it's the same schedule, but you guys have to go to East Point Police Department. And again, sir, I'd suggest you contact East Point District Court and figure out how to resolve that warrant if in fact you have one. Okay.
Yes, sir. Well, I have one more question. So yeah. you said that I'm responsible for reimbursing Mrs. Sutton's attorney for her filing a complaint against me.
I'm going to have you contribute to her attorney fees. She paid $1,500. I'm having you pay $5. You can object and go before the judge if you don't like that.
Okay, I'll do that.
Okay. All right. And guys, if you have any questions, procedure, you will get the objection procedure along with this order. Okay. But guys, realize that the judge may, because she could increase that, decrease it, or just as an aside. So realize whatever the judge decides will be the final order. And if it's different than I did and she increases it, that's the result as well. I'm just putting that out there. Okay. All right. All right, guys. With that, we will email you a copy of this order. You shall get it before lunch or by 1 this afternoon. If not, you don't have it by tomorrow morning. Check your junk and spam. And if you still don't have it, give my office a call. All right. Okay. And we're here this morning on defendant's motion requesting to show cause plaintiff for failure to comply with the court order to sign up with our family wizard and for clarification related to the minor child schooling. And counsel, you're welcome to proceed with your motion.
Thank you, Your Honor. And I don't want to run this too long. I know the court has heard arguments on this matter before. As of Friday, when I did my last check, he had still not signed up for Family Wizard. You know, I don't know what the problem is. There have been 2 previous orders, one by Your Honor and one the court itself with Judge Jennings. I believe one back in June of last year, and then one this year, just a couple of months ago, when we appeared before you and you ordered them to sign up within 72 hours. Our client did so. She paid. Mr. Hardy has failed to do so. And because of that PPO that's in place and the criminal proceedings against Mr. Hardy and his inability to communicate with Ms. Smith, it's just making this a very difficult transaction. That leads us to the issue with the school, where he unilaterally went in, signed the child up for the school across the street from his house. I recognize that the child did attend that school at one point in time. However, at this point, Ms. Smith lives half an hour away. The school that she attended last year is still only 5 minutes away from Mr. Hardy's home, so it's closer to Mr. Hardy. However, it's the school that the child used to attend, and this school offers daycare, which allows Ms. Smith to drop the minor child off, early risers type program, and then go to work. She works at Five Guys. I know it's not a, CEO job at Ford or what have you. However, it is her job, and that's how she's able to support her family. We were in court just last week when Mr. Hardy testified in front of the Honorable Judge Jennings that his schedule at work is extremely flexible. He's able to do what he wants and how he wants to do it. Well, Ms. Smith doesn't have that luxury, and she's on the verge of risking, losing her job. So we don't want to do anything to upset the court, and we want to make sure we're following orders. So we wanted the court to step in and enter an order related to the schooling, and then figure out what we can do to make him sign up for Family Wizard, so we really can get on track with making sure the child is, where she needs to be. For example, if one of the parents is sick and the child needs to be picked up, or if the child is sick and needs to be picked up, and the parents can't communicate because there's that no contact order and the PPO in place, how does that work? I don't know that he's understanding that. I know he tried to do it through our office for a long period of time, and respectfully, although I would love to be able to babysit every single client, but that is just not something that my office can do. So
remind me what the no contact order, what that charges and what that's in regards to. Is that
an assault and battery? And I think it's a little more than assault and battery, so I don't want to misquote for the record, but there was an instance where him and his girlfriend attacked Ms. Smith. There's
okay. So in regards to that's a pending charge that has not yet come to finality.
And I understand he is
and where
in Wayne
okay,
County.
go ahead. Wayne County District or Circuit?
Circuit. And last I checked, that for hearing, I think end of October or something of this sort. Right. Set for trial.
Okay. All right. And is there a provision of that bond that cuts out an exception for parenting time exchanges or no?
There's no. So he picks up from the school, and the PPO was actually by Jennings. It wasn't the no contact is entered by the circuit judge, and the PPO was entered by Judge Jennings.
Okay. And so what happens if there's no school in session? What do you guys do then?
And that's the problem. So our office was trying to help them work through that, but we can't be involved in that. We submitted emails the last time when Your Honor worked a 72-hour deadline, and this is the second time.
Okay. So do you guys have a third party? How do you guys want to effectuate parenting time exchanges if there's no school on that day?
Well, we've been meeting at the police station, Your Honor, or in some instances, she'll pick up our daughter from my auntie's house, which this same lawyer has complained that I don't work with or I refuse to work with. Ms. Smith knows everything that we have done has been very smooth in all of our transactions. There have been some hiccups, yes, I will admit, on both of our parts. And I don't sit here and attack Ms. Smith in any type of fashion. I have to stress that this is just a pure manipulation of the system in a way. But
are you trying to communicate through counsel? Because if you try to communicate through her, she's going to
we don't. There has not been a genuine need for us to communicate, and we've been doing this for the latter of since January, Your Honor, the end of January. Without any, I think I would have been arrested by now if I would have broke any type of order or of any type of misconduct against anything of that nature. I'm trying to express to you that this.
Yeah,
is
but you're not going to. Well,
you won't
get. You're not going to get arrested for contacting counsel, but counsel saying she can't be. Okay, you're not talking about that.
I'm sorry.
Okay,
Yeah, I'm not talking about that. I'm talking about this pending case that I have coming up that I am innocent, but until proven guilty. But I can't stress that enough because, like I said, this is just a genuine manipulation of the time, and I can explain every point that she has brought up and why it's been a manipulation.
Okay, so well, guys, I'm not. This isn't criminal court. I just have to deal with. You guys have no contact order. I can't change that. I just don't want somebody getting violated on it. At a parenting time exchange. Okay.
I'm sorry. The thing is, though, when she brings up that there's no way for us to like if I'm unavailable for her, like when she comes to the schooling issue, she brings up that the school is only 5 minutes away and all of these different type of reasons why she had to remove my child from a school that she has been going to since preschool. And we've already agreed. I remind you, last year we were living together. Not together in a fashion as a relationship.
Okay. But where? Okay, so let's get to the school. So you guys know that as joint custodians, you cannot unilaterally change the school without mutual agreement or order of the court. So where did what grade is your child in this year?
She's in the 4th grade now, and we discussed why remove her from all of her friends in the 3rd grade when she just has a couple more years to finish out, and then we can explore different options for her to go to a different school. We discussed. Well,
where did she go last year?
She went to Tyrone Elementary down the street.
So why isn't she going to Tyrone this year?
Because she went back to the same school that we both agreed on. I've never agreed for her to go to Tyrone Elementary. She did that using a manipulation tactic, knowing that when I had got arrested last year, she knew we had no contact order, and then removed my child from that school, and we had no reason. There was no she was living in my house.
She's saying her reason is that her work schedule, the new school doesn't permit for early childcare. And she
brings that up, and that's perfectly fine. But see, in our last proceeding, she said, I don't know why Mr. Hardy won't communicate with his auntie who lives right across the street, and they can work something out where the child can go there. But now in this proceeding, she doesn't bring that up. This is a manipulation because my child does.
You're claiming you're claiming that when you guys were in front of Judge Dennings in September, she said your child could go to Tyrone.
No, not to Tyrone. To my aunt Sherry's house, who lives directly across the street. She lives directly across the street, and she tried to express that me and my auntie do not get along. We don't communicate, but she doesn't know that. They think they're so involved in my life, and they're trying to manipulate.
I know, but so let me ask it. So how is Ms. Smith handling? So where's your child going to school right now?
Right across the street from my house at Marquette.
So ma'am, how does that affect on your days with your work schedule? How have you made that happen?
Okay, so currently, it's just really it's been really tough these past couple of weeks just because I'm required to be here at 7 a.m. To do paperwork, all of that good stuff. I can't get here at 7 a.m. because they don't allow the kids go into the school until right at 7:30. They start school at 7:30, so they open the doors 5 minutes early. So not only am I being late, but I also have to leave work to go pick her up because they don't offer latchkey, whereas the other school has latchkey. So typically I get off at 4 o'clock, in between 4 and 5 o'clock. Nyla typically at Tyrone, she would get out of school at 3 o'clock, and then she would stay at latchkey for an hour to an hour and a half, where she was able to do homework, get tutoring. She was in a book club, all sorts of stuff like that. With Marquette, I constantly every day have to leave work early, have to leave work at 2 o'clock, and then I have to come back, drop her off somewhere, come back. And it's just becoming a hassle for my bosses. Like I had told my attorney, I'm in training to be a district manager with the company, and it's just, it's not looking good with me being late and consistently having to leave to go pick her up.
Okay.
Your Honor,
Go ahead, counsel.
I'm sorry. I don't think he's understanding the situation. No one is trying to manipulate anyone. There's an order that says he's supposed to sign up for Family Wizard. He's just not doing it. He provides no explanation for why he's not doing it.
I can explain.
No, but you said
So counsel, if you're making the point he won't sign up, I need his response of why he hasn't.
It's not a refusal to sign up, Your Honor. That first week when we were supposed to sign up, I emailed her, and I guess she didn't want to read my emails, or because she did explain to Judge Terry Dennings that she doesn't want to be the communicator or between us and Jasmine, which that's completely fine. But I emailed her And I had tried to respond to this motion, but I guess I must have did it wrong on Friday.
Okay, so I don't want to hear the histrionics. Tell me why you haven't signed up for our family. That's all you do.
I am unable to sign up. There's something wrong with the technical portion of the app. I've called the IT department. If there's a way where I can email you the same thing that the pictures and everything, I'll do so right now.
Have you called our family wizard?
I've called them. They sent me a link. I click on the link and the link leads to nowhere. So I called them back.
Did you call it? Okay.
I call them back and they say, okay, they'll email me in about a week with a response. Typically, 5 business days. But I think I had called on a Thursday, so I had to wait until I think I got a response on a Tuesday. I don't remember the exact date, but nonetheless, I made several attempts. I showed phone call history, the emails that they sent me, the email that I sent her showing that at the very bottom it said that I already had an account for something that I never signed up for. So when I used my work email, the same response, and I don't understand because clearly I've never signed up for this. So when I did make the actual attempt by your order within 72 hours, I got that response. I can show you.
Yeah, but realize why it's probably you said you have an account when the first person signs up, and then it's supposed to send the other person an invite. So it sets up the account.
I've never received an invite.
It's on there. And then you would have got a direction from them.
But it won't let me go in there and sign up at all, Your Honor. It won't let me get past.
And have you called them back again? So when's the last time they said they were going to email you about why it's not working?
They said they're going to email me this week. I called them last Thursday, not Thursday, last Friday. Last Friday. Well, actually, I called them 3 days in a row: Wednesday, Thursday, and Friday. Because
Who did you remember who you talked to? Did you talk? Did you talk to the regional head? Who did you talk to?
I didn't get a name.
Was it a guy?
It was a guy. Yes, I was directed to some male, and I can screen share on my phone right now and show you the exact sign up process.
Okay. So I need you to keep working on it.
Absolutely. I don't have no issue trying to communicate. I don't necessarily want to communicate with Ms. Smith because clearly I can't see why nobody's understanding why this woman and this lawyer are only trying to manipulate the system to
listen, guys, Mr.
It's frustrating. It's frustrating because all I'm
but realize, Mr. Hardy, stop. When I talk, everybody stops, including you. When I talk, you don't talk. That's how it works. So, Mr. Hardy, Counsel cannot make law enforcement request a warrant or the prosecutor prosecute you. They can't make that happen. Law enforcement makes that happen in a prosecutor. So they can't make that happen. They've decided that based on whatever was presented to them that they brought charges. That's where we're at with a no contact bond and now a PPO out of Judge Dennings. That's the working what you guys have to work with. So guys, I'm going to issue my decision. So guys, if your child was in a school last year for a year, you can't unilaterally put your child back in the other school, sir. You can't.
Your Honor, she took her out of school in the first place. She was already going to a school that was already, if she can't do that, why can't I return? I don't understand why we can't go back to what was originally discussed and already in place. How am I wrong?
You don't think it's reasonable? You don't think it's reasonable that Ms. Smith, one school has childcare and the other one doesn't, that she can happen or the other one?
That's completely understandable, Your Honor, but when she brings up to Ms. Judge Lennings that how come I don't utilize my auntie, they don't have a problem using her as a buffer between us when the child is
I know, but how does your aunt acting as a buffer have anything to do with school?
Because we live right across the street. If Nyla gets out of school, I allow my daughter to walk home from school. I'll stand.
You're saying that you're saying that Miss Smith could drop your daughter off early in the morning to your aunt and then pick her up at
absolutely. I'm here as well, Your Honor. I'm here as well. She can drop her off.
Have you ever had message her in any way to tell her?
I never contacted her.
So Miss Smith, what's your thought? You can drop off to him or his aunt and keep her in the current school. What are your thoughts about that?
The thing with his aunt is she works for Quicken Loan, so she goes into the office. There's days that she goes into the office. So, I'm not 100% sure about any of that. Like I said, the latchkey program is just very beneficial. Like there's some days where the aunt is not going to be able, like I won't be able to drop her off, or I won't be able to.
Let me ask this. Do you feel it's more beneficial that she stays in the current school and utilize and drop off to his aunts, or do you think she'll handle being yanked out of the school and putting back after a week or two of school?
She wants to be at her original school.
Mr. Hardy, Mr. Hardy, stop talking over me. I'm going to figure that. You know what? Listen, you're currently charged with a crime that it says you can't control your temper. So So I may assume if you keep not listening to me and talking over me, that's evidence that you can't control yourself. So you probably want to listen to me, right?
I'm listening, Your Honor.
So Ms. Smith, so you're going to be potentially having your daughter being taken out of school and after the first of the year and all of those bonds have formed and she's going to be going back. You think that the other school is superior and that it's worth it to do that?
I do. I do. And then I also asked her, this past weekend, how she felt about going back to Tyrone, and she really wants to. She has a best friend there. She met a lot of good friends there, that she keeps in contact with. They talk on the phone over the weekends. One of her friends is actually grandmother started the book club that she was in. So Nyla really enjoyed going to Tyrone. And like I said, they just offer more programs, even with the tutoring and just little clubs that they have to offer that Marquette doesn't have to offer. Nyla is very smart. She's very, she's just really, really smart.
Okay. So Mr. Hardy, do you have any conversation with Ms. Smith before you switched schools?
She didn't have a conversation with me before she switched school. I don't know why we're so focused on me switching schools back to what we had previously.
Because it's a year down the road. You can't say I'm doing payback for 2 years.
It's not payback, Your Honor. That's what we both
listen, her school. She didn't, because she went to a different school last year.
But she did that without discussing it with me.
Guess what? It's too late though. That's too wrong.
That's unjustifiable in so many ways.
Okay, so I want you to stop talking. I'm going to just stop because I'm going to make my rec. It's not a back and forth argument. I give everyone everyone's made their points fully.
Okay.
The point I'm making is you might not agree with it, but the last school year was at Tyrone. The last school was not at Marquette. The last school was Tyrone. And you can't say, well, the last year she switched to Tyrone and therefore I'm going back to 2 years ago. That year at Tyrone established Tyrone as the school. Once that was established, you have to get permission of the court. And so she got to go back to Tyrone. You'll have to object and get in front of Judge Dennings again. And guys, you've met her. So you should you've had a little feel for the judge. How she works.
She's been agreeing with everything that I said. That's all I don't understand. You went against her judgment, even though I explained to you that's what she decided. And you're telling me that she's the overall precise judge.
I'm making my rec. I'm telling you, if you don't stop talking, I'm going to unmute you. So you can disagree, just like you did before, guys. You file objections, you get before Judge Dennings. You've already met her. You just had an objection here, and you can do the same thing to this.
Will do.
She may feel differently, and she's the boss. The judge is the boss. So she may agree with me or not. So my recommendation is 1, the minor child shall be returned to Tyrone Elementary, where she attended the 22-23 school year.
Your Honor, may I say one last thing, please? And then I have nothing to say. This is completely wrong. And she's taking her sister away from her. They're separating my sister, the sisters now.
So tell me about that. Tell me about that.
My daughter does not want to go back to Tyrone Elementary.
I don't want to hear what your daughter. You told me about a sister. What? Tell me about that.
Her little sister goes to Marquette Elementary, and they walk to. I walk.
What grade is her little sister in?
Preschool.
Okay.
And
all right, I've heard you.
And all I'm trying to do is do it for my children. I have to work hard to make the sacrifices and within my career, within everything that I do in life. All I do is for my children. Right. And I'm sitting here being demonized.
We are done talking. We're done talking. We're done talking.
Please make your judgment.
You are done talking.
Thank you.
All right, I am going to stand by what I said. You have to mutually agree as joint physical custodians to change the school.